Let me ask you the question that can you sell your grandmother's promise to give you her house? Can you rent your right to sue someone or sell your government pension to somebody else? Well, law says a big no to it. If you want to know why, this video is for you. Hey everyone, welcome back. Today we will talk about a super important topic under the Transfer of Property Act 1882. What kind of property can be transferred and more importantly, and what cannot be transferred under section 6. The law allows us to transfer most properties, but there are some exceptions, and those are what we will going to deeply understand in this video with an example so you never forget. So let's get started. First of all, let's see what is transferable property. Transferable property simply means any property that can legally move from one person to another. You can sell it, gift it, lease it, all that. Section 6 of the Transfer of Property Act says all properties can be transferred unless there is a law that says otherwise. Now let's discuss about that properties which cannot be transferred. I'll explain you with each and every point in very detail. So first property which cannot be transferred is spes successionis. That means a hope, not a right. Spes successionis is given under section 6A. What is it basically? A mere hope or chance to get property in a future. Means, let's take an example. Imagine this. Arun is hoping that his aunt Chandani, who has no children, will leave her bungalow to him. He gets so confident on that, he sells that future hope to Bhushan for rupees 1 lakh. But guess what? This transfer is totally invalid. Why? Because Arun is only hoping. There is no legal right yet. This kind of future possibility is called spes successionis, and the law says you can't transfer a mere chance or expectation to anyone else. So this transfer will be totally called invalid transfer because you can't sell what you don't own, and a future possibilities is not a property yet. That means you can't sell a dream. A dream is not a property. Now second property which cannot be transferred is right of re-entry. It is given in section 6 clause B. First of all, let's see what is it. A landlord's right to take back land if a tenant breaks any conditions. Let's take one example. A gives a piece of land on lease to B for 5 years and says you can use it but don't dig a well here. If B breaks that condition on that particular situation, A has a right to re-enter and take back his land. But can A sell this right of re-entry to C? No, this also cannot be possible because this right is personal to A and it cannot be transferred independently. So the law prohibits the transfer of bare rights of re-entry. Re-entry is like a personal revenge clause. You can't pass it on. Now let's discuss another property which cannot be transferred. That is easement rights. Easement rights that is given under section 6 clause C. What is it mainly? A right to use someone else's land in a certain way. In this, let's take one example. Think of this. Your house has a small lane going through your neighbor's backyard that you have used for years to exit. That's an easement. A right over someone else's land, but you cannot sell just that easement property to someone else. Easement rights can only be transferred with the main property called dominant heritage. If you are selling your house, then you have to sell with it, so you can't transfer them separately. You cannot sell your house to somebody else, or you cannot sell your easement way or path to somebody else. You have to sell both to one person at a time. You can sell it jointly. You cannot transfer it separately. Now another property which cannot be transferred is restricted interest, that is given section 6 clause D. What is it mainly? If someone is given for your personal use, you can't pass it on. In this situation, let's take one example. If someone given you their house just for your personal use, can you let someone else use it? No. Suppose the owner clearly said you can stay here but only you, not anyone else. Then you cannot transfer your right to someone else. Why? Because the enjoyment is restricted to you only. Even trustees can't sell or give away their position because it's based on personal trust and responsibilities. Basically, in short, we can say it, you can't gift personal enjoyment. It ends with you only. Now another type of property which cannot be transferred is right to future maintenance. It's given under section 6 clause D. What is it? The right to receive future financial support. It basically means, let's say a woman is legally entitled to receive monthly maintenance from her husband. Can she sell that future right to someone in exchange for money? The answer is no. The law says right to future maintenance is for personal benefit only. It's not something you can sell or assign to anybody else. However, if she has arrears or unpaid maintenance, she can transfer the right to recover it. But the maintenance is care, not currency that you can cash it out. So right to future maintenance also cannot be transferred. Now another type of property that cannot be transferred is mere right to sue, that is given under section 6 clause E. So what is it? The personal right to file a case or claim compensation. This one is super important. Suppose your contractor did not finish your home on a given period of time and you want to sue against him for damages. Can you sell that right to someone else? Like, hey, I'll give you my case, you fight it and take the money. No, because right to sue is a personal to the victim and the law says you can't sell your grievances to anybody else. Justice is personal. You can't hire someone to feel your pain. Another type of property which cannot be transferred is public office, that is given under section 6 clause F. So what is it mainly? Any government job or any position. This is simple. Let's imagine if someone says, hey, I'm a government officer and somebody else wants to buy my position, that would be illegal, dangerous right, because public offices are based on personal skills and responsibilities. They cannot be bought or sold. If somebody is doing this, that means goes against public policy and law strictly forbids it. Public service is not a product. You earn it, not trade it. Another property which cannot be transferred is pension, that is given section 6 clause G. What is it mainly? It is a monthly allowances after retirement from the civil, military or political jobs that person has been done in his past. Let's understand with this an example. Your grandpa receives a military pension. Can he transfer it to you so you start receiving the money instead of him? No. Pensions, whether for military, civil services or political reasons, are rewards for personal services and the law does not allow them to be transferred to anyone else. A pension is a thank you from the nation, not a paycheck to be passed around. Now next property which cannot be transferred is properties opposed to nature or law, that is given in section 6 clause H. There are three situations here. First is property which opposed to the nature of interest. That means things like air, river or public property which belongs to everyone. It can't be transferred. They are called res nullius or res communis. Second situation is unlawful object or consideration. If you rent a house to run a gambling den or a brothel, that transfer is totally invalid because the purpose is illegal and law does not support immoral or illegal transfers. Third situation is person legally disqualified. Someone who is not legally allowed to own property, like an enemy alien or a minor in certain cases, that he can't be the transferee. Another type of property which cannot be transferred is statutory prohibition, that is given in section 6 clause I. So what is it basically? Some properties are restricted by other laws. This is all about specific laws that stop certain transfers. Let's take an example. A farmer who has not paid land revenue can't transfer his land interest, or tenants with non-transferable rights can't lease or sell those rights. These are called statutory bars and they override general rules. When the law says stop, even ownership takes a pause. So friends, while the law generally allows people to transfer property, section 6 of the Transfer of Property Act 1882 acts like a filter. It ensures that only valid, meaningful and legal transfer must be happen, whether it's a hope or public office or a pension. If it does not have legal standing or goes against public policy, just can't transfer it. So next time you think, can I sell this? Ask yourself, do I really own it or is it legally transferable? Because in law, not everything that looks like property is sellable property. So this was our whole lecture about the Transfer of Property Act, and we seen in this what section 6 of the Transfer of Property said, or what type of property can be transferred or what type of property cannot be transferable. So this is it. If you found this video helpful, hit like, share with your law buddies and subscribe for more legal clarity.